Andrew has mediated disputes in the UK, France, Spain, Germany, Lithuania, Turkey, Canada, USA, India, and the Philippines. Okay, I had to hold my breath there. I know you're not empty. So over to you.
Okay, thank you so much, Abby. Now, Andrew, like I said to you,
thank you for that introduction.
You're welcome. So yeah, it's a packed day today.
It is a packed day today. You can say that again. So I remember my conversation with you, and I told you we had to bring you back by popular request for two reasons, essentially. A lot of people we had a conversation with on Instagram could not really have that proper one-on-one conversation with you. In fact, it was even one of the reasons why we had to even come to Zoom, because people wanted that that feel of connecting with the essence of a lot of the things you say. So I may have to ask one or two questions that I asked before, and then we'll now build up a narrative from there, if you don't mind. Thank you so much.
I'll try and say the same answers, but I've probably forgotten what I said. I will tell that yeah, no comparison.
No comparison. And for those joining us for the first time, you're welcome to the Mediation Hot Seat. I must say that this is not a training session. This is where we get to connect with the essence of mediators on contemporary issues surrounding mediation. So if at any point in time you have any question, feedback, or comment, kindly drop it in the comment section. And if you feel you need to speak to the mediator on the hot seat, please indicate by raising your virtual hand. So as always, we believe that the journey is as important as the destination. So Andrew, can you please, let's talk about your journey into mediation. Like I said, what I had actually a question, your QC is the equivalent of a senior advocate of Nigeria, which is the highest point any senior advocate can have in law. So we're curious, a core litigator and a mediator. So why mediation? Can we just have an insight into your journey to mediation?
Okay, that's a big question, but I'm going to try and give it a small answer. So I worked as a commercial barrister, and I was a commercial barrister as a junior and became a QC when I became senior. And if I was an American, I would no doubt call myself a trial attorney, because what I did was essentially litigation. And I specialize, has been kindly read out by Abby, in terms of construction, insurance, professional negligence, but it was all commercial things. And my day-to-day work was working on cases that were either going to court or were going to arbitration, either in the UK or in different parts of the world. And I was, I guess, fortunate that a long time ago, and it's now over, it's 25, 26 years ago, when I was very junior, I was working on a construction case with an American firm who had instructed me. And I was quite junior on the case. There was a QC on that case. And the in-house counsel for the company that we were working for told us that we were going to do this thing called mediation. And I didn't know whether when he was describing it, whether he was talking about medication or meditation. This was not something I was at all familiar. It was something I was not taught. I think I was 4 or 5 years qualified. And it sounded pretty interesting, but I had a QC, a Queen's Counsel, with me. And when the in-house counsel left the room, the QC turned to me, and he was sadly, he's no longer with us. He died quite a few years ago, but he was a very proper QC. And he turned around to me and said, "What a load of shite." And in fact, what we then saw over the next, and it was over when it started, it was actually a 3-day mediation, was a totally different procedure. He may well have maintained his view, but I saw that this was something different. So what happened throughout my career, and I worked a lot with American firms, was that I was lucky enough to see mediation an awful lot. And I was a mediation advocate and an advocate for mediation all the way through, using it a lot for my clients. Because the one thing that I learned, maybe not initially, but certainly as I got more senior and as my cases got bigger, was that even when I won cases, it was still a rare thing for clients to thank me. Sometimes they did, but it was quite rare. But the one thing I could say 100% for sure was that at the end of any litigation or any arbitration, the end of a trial or an arbitration, no client ever came to me and said, "Thank you, Andrew, for keeping me in dispute. I really appreciate that. I've lost my wife, my husband, my kids, my business, but I really want to thank you for the journey, for the last 1, 3, 5-year journey that you've given me." And I guess I came to see, as much as I subscribed, and I did very much subscribe to the Lawyers Benevolent Fund. It paid my mortgage, put my kids through school, gave me an awful lot. I saw that that litigation generally was a mug's game, and it didn't matter if it was small or it was large. It affected people in certain ways. So I saw, and this comes to your question, Phil, I saw mediation and settlement as being very, very important parts of my practice. But despite having a huge respect for mediation, I did not develop the same respect for most mediators. And I struggled with the fact that I would have to say the majority of mediators I did not think were that good. And it was simply, it was pretty obvious why. It's totally unregulated. It takes years to become a lawyer. It takes 5 days of your time if you want to get a piece of paper that says you're a mediator. And I started to think, well, I want to perhaps try stepping out and doing the other side. And that's what I started to do. So I started to combine doing mediations and working as a barrister. And although it may seem strange, the cases I did and the cases I still do were the same cases that I would do as a barrister. So I got my work as a mediator started and has continued in respect of doing the same type of construction cases, insurance cases, professional negligence cases. And I was very fortunate that when I dipped my toes in the mediation pond, they got nibbled quite quickly. And what it meant was that I could actually then start looking at mediation in a different way, taking everything. My mediation training was 25 years of dispute resolution. And as I say to my people I'm mediating with, to those who retain me, I don't leave that at the door, I bring it in. So that's what I did. I never anticipated initially that I would stop being a barrister. I thought I would do both, but effectively I managed to combine both for 3 years. And then the mediation work was taking off. But there was something else. I realized I was enjoying it more. And I'd had 25 years of plus by then of being a trial attorney, a litigation, adversarial, in an adversarial role. And suddenly here I was doing a new job. And it is, what I realized is, which I didn't think it would be, it's the fascination side. It's actually seeing how things are working on both sides and then trying to bring people together, trying to make them see things in a different way, trying to change perceptions. So it is a different challenge, but as challenging for me as standing up in front of judges and arbitrators. And I guess after 25 years, I was quite ready to get a new job. That's a long answer for a short question, but it's
it's a good one because I've noticed that the bulk of the conversations we have here on the mediation hot seat centers around three things. Number one is the growth of mediation, and number two really is the antagonistic nature of lawyers towards mediation. So I'm going to start with the antagonistic nature of lawyers towards mediation. As a QC, and I don't know whether to call you an ex-core litigator, in your opinion, why do you think lawyers are antagonistic towards mediation as a preferred means of dispute resolution? If you were to try to get into their minds, you really know why they don't like mediation, for want of a better way to put it.
So I think, having spoken to you, Paulo, and I don't know a great deal about the lawyers in Nigeria, but so what I've learned, and I apologize if I say anything out of place, but you'll have to understand everything I know comes from FOLA. I think the words you used are probably right. There's a great hesitance or dislike, antagonism towards it where you are. But that still exists even in the UK. So why do I think it is, or why do I know? I think the starting point is ADR. It's it's what we call the elephant in the room that people aren't willing to talk about. And that is, for many lawyers, their perception is that ADR means acute drop in revenue. And sometimes it does, but it doesn't have to. And I think what the difference is, it's often where you see your role as a lawyer. And most lawyers see their role as being the individual who can make it better for their client. But lawyers have something, and they can't help having, because to be a lawyer, wherever you're a lawyer, whichever country, takes a lot. You've got to get to university. You've got to do, whether you do a law degree or not. If you don't, you've got to, in the UK, you have to do a conversion course. It's at every stage. You can't just say, I want to go to university. You've got to be good enough to get into university. You can't just say, I want to go to bar school or law school for a solicitor. You've got to be good enough. Yeah. You can't just say, I want to be in a chambers or in a law firm. You've got to be good enough. So by the time you get there, you can't help but have an ego. And I don't think if you don't have an ego, I don't think you can succeed as a lawyer either. So you have that. So it's a very natural thing to think that you are the person who holds the answer for your client. But that answer is dealing with it in the way that you think it should be dealt with. And if you just step back for a moment, if you could get lawyers to step back and listen and say, do you think that the best thing you can do for your client is to make submissions in court in front of a judge? Is that what your client really wants? Do you think the best thing you can do for your client is spend 50, 100, 500 hours reading documents? I could go on. Do you think the best thing you can do is to spend money on expert for it? Or do you think the best thing you can do for your client is actually stop this dispute, bring it to an end? And if you could ask someone to give an objective answer, they would always say, yeah, I imagine that is the best thing I could do, to stop them paying. That means they would stop paying any further money. But lawyers don't think in those terms. They maintain that whatever they're doing, they're doing for the best of their client. And I think it's an ethos. It's not. I don't say this as a criticism, because I am a lawyer still, and I was a lawyer, and I'm a lawyer mediator. I'm very much, that's how I sell myself, that I understand the dispute resolution. But I think that the problem lies in how lawyers perceive the right way to do things. So let me give you, when I give a talk, I actually give an analogy, and I think it's actually, it's often quite helpful. I may have told you this last time, Fola, so apologies if I'm repeating myself on this one, but I like to use this one. So if you imagine you have a rash on your arm, and you go to the doctor, and you show the doctor your arm, what you're really saying to the doctor is, here's my arm. There was a time yesterday, last week, whenever, last month, when it didn't have a rash. I want you, as the doctor, to put me back in that position where my arm didn't have this rash. And the doctor will give you cream or pills or whatever, because the doctor's aim is to put you where you were before you needed the doctor. And if you contrast that with a lawyer, you go to the lawyer and you say, I have a problem. I was selling goods to this person and they paid for years and they've stopped paying. Or I was buying goods for years and the quality was good and now it's no good. I have an employment problem, whatever the legal problem is. And what anyone going to a lawyer is also saying, the same as going to a doctor, is I was okay before. Something went wrong, but before I was okay. And what the lawyer doesn't hear is that. The person is saying, I have a problem, but I want to be in the position I was before the problem. And what the lawyer does is say, we're going to deal with this, but come with me. Come with me, and I am going to take you on a journey to solve your problem. And the lawyer keeps moving away from where the problem started. Problem started over here, and the lawyer's going to keep moving and moving, so you can't even see it's off screen. And the further the lawyer takes you down this road, the more difficult it is for you even to remember what you went to the lawyer for in the first place. And that's why and it's not the lawyer's fault. The lawyer's not thinking, I hate mediation. The lawyer just starts on a different road. And that's why slotting mediation in at different junctions of that road is difficult, because it breaks the journey. And the lawyer has their sight on each stage, on the next stage, the next stage, the next stage. But it also becomes more difficult for the client the further you go down. Because what most of my mediations are about are not the dispute, not the original sale of goods, not the original employment problem, land problem, whatever. They're about the legal dispute. That problem is way over there. And we're now talking about hundreds of thousands, sometimes millions in fees for fight.
Yeah.
That's what the dispute comes.
Yeah, sorry, Andrew. Let me expand this narrative, and this is me walking on eggshells. Do you think lawyers are forgetting their core? Do you think we are losing the essence of being lawyers? Because if you look at the way they make cases all about them, and not the clients, and not the justice of the case per se, do you think we're beginning to lose the very essence of why we are lawyers? First, as dispute resolvers. That's the word, dispute resolvers, before any other thing. And another elephant in the room, which we don't always like to talk about, is the issue of money, the professional fees, the inability to justify their earnings, which some of them don't even understand via mediation, because mediation is essentially party driven. The bulk of what they will do with the client will be outside the mediation session. So I don't know whether we are beginning to lose, for want of a better way to put, our humanity, or what exactly do you think could be the problem, that elephant in the room that makes lawyers just say, you know what, no, I'd rather just stick to the issue to litigation and not allow them to go through mediation? Are we losing our calling? Oh no, are we forgetting our calling? Yeah, that's the word.
Well, I can see, you're younger than me, Fola. You used a phrase Are we forgetting we're dispute resolvers? Lawyers have only become dispute resolvers in the last few years.
Oh, interesting.
That's just the name that they've taken up. Lawyers were never dispute resolvers. Lawyers were lawyers. The only dispute resolvers were the judges. It was not a lawyer's role to resolve a dispute. It was a lawyer's role, and always has been, to take that dispute and to fight it. They're fighters. That's what I did for years. That was my training, to be a fighter. And you know, I'm trying to think of the quote, but so there may be someone who's far better than me. But it was Shakespeare. So we're going back
We're Spartans. We're gladiators. We're gladiators.
Yeah, but Shakespeare 400 or 500 years ago, whenever it was, said, "Kill all the lawyers." This is not new. You know, that's in one of Shakespeare's plays. Lawyers aren't there. Lawyers, that's the point. Lawyers' job is not there to resolve. That's the lawyers were not created for that. For that, it was to fight a side. So what has happened is only in very recent years, in the last 10, 20, maybe 30 years, that the idea that maybe, just maybe, it's better for the client to have that dispute resolved. And I think that's the key. So I don't think they're forgetting it. I think it's an education that has to happen. You have to transform. But I have to say, my American colleagues, I think, and I say this when I look back, perhaps with some surprise, got mediation right. And I actually had one American attorney I worked with for many, many years, and became a close friend. And we were dealing with a matter that was actually being dealt with out of the UK. And I remember his phrase to me, this was, I can actually tell you, it was in 2001, so 20 years ago. And he was sitting there, he was the only American, it was me, there was a Queen's Counsel, there were other English solicitors, and he just suddenly went, "You know what? You guys just do not get mediation. You just don't get it." And he sort of explained when mediation arrived in the States, the US lawyers saw it not as a acute drop in revenue, they saw it as another string to their bow. They actually saw it as money making. They saw it as something they could offer to clients as a positive and still charge them, because they recognize there are some things, although the general idea is that the US is so litigious, there are still some things where they know court isn't going to suit it, but they can work on a mediation geared case. So I think that they're ahead. I feel the UK has in some respects, in some areas, caught up a bit, not fully, but in other practice areas, not at all. So I give you an example, in the insurance world, lawyers have had to learn that insurers prefer cases to settle. So they've had to embrace mediation a lot more. The only difference is they don't embrace it early enough. I do a lot of work in the construction field that lags behind, absolutely lags behind. So I think the short answer to your question is, they haven't forgotten. I don't think they ever had the calling you said. Lawyers come with an ego, and that ego won't disappear. It's going to take an awful lot for them to learn that their ego is not their amigo.
So if you ask me, I think that ego is tied to that wig and gown. I think there's just something about that wig and gown that when we lawyers put on, we just become something else. I don't know. Okay, Abby, you can please take over. Please take over from there.
Okay, so Andrew, would you say, so from what you just said, it wasn't part of the training. It's not part of the training we had. So we had an adversarial upbringing training. So would you say we have to go back to the educational system to recalibrate training process? And then, okay, go ahead.
Yeah, no, well, I think it certainly wasn't part of my training. I mean, I was at university, I hate to say how long ago, but I started university 80 years ago. So it wasn't part of the training then. There is more training now about mediation. I think you would struggle to find, certainly at the year, which is what we call, it's got a different name, but in my day it was called bar school, and solicitors did go to what was then called law school. It's now got a different name, but there will be training on mediation given then. There will be training at many of the universities. There's a lot of opportunity to learn about mediation. So I guess where it comes in, you have a whole generation around my age and younger, but my age younger and older, who did not grow up with the training of mediation. So I think it's there. In the UK, I don't think it's that good. And I think as a couple of people on the line know, I do a lot in India, and they are I wouldn't say training, educating about mediation, educating. But there's something else that's going on in India. It's the judiciary who are involved a lot with talking about mediation non-stop. We have a new Master of the Rolls and a new Chief Justice in England, in the UK at the moment. And they've been making a lot of noise about mediation, but others have in the past. It'll be interesting to see what happens with this increased noise about mediation.
Okay. So you also mentioned about the fact that all you need to do is dedicate 5 days and become a mediator, and the amount of time spent in school to become a lawyer. So would you say that a combination of that and the ego is part of the reasons why there's there's friction? Lawyers are antagonistic.
Yeah, I would say that I'd call it something else. I would say there is not all lawyers, and so I won't put all lawyers down, but I think it comes down to the word respect. So in one of the talks I give, I talk about the relationship between mediation, litigation, and so lawyers, litigation and mediation, and lawyers and mediation. And I talk about one of the reasons why it takes so long, often for cases, to get to mediation, if they get there at all, in the UK. And one of the lines on that particular slide is the respect of the lawyer for the mediation process. And it is a fact that, well, let's say, it's not a fact, it's my view, let's put it that way, that there are many who do not have a high respect for the mediation process. And for me, it's very easy to see why. And it comes down to that point. How can it be that it is so difficult to become a lawyer, a dentist, a doctor, an engineer, but so easy to become a mediator? And how can you have respect for a profession, if it is a profession, and I hope it is? How can you have respect where people can come into it after 5 days, and even come into it when they have no knowledge of dispute resolution? And most mediation, commercial mediation, is part of the litigation process. It may not even have started. It may be pre-litigation, but generally it's still part of that. So I think that that is one of the problems. It's got worse in COVID because mediation training is big money, It's a fantastic money spinner for the organizations, and now so many private mediation schools that have shot up. I think there's something like 30 something plus mediation schools in the UK at the moment. And they've now moved to online training. And I do struggle with how you train someone to be a mediator in that short period of time. You can't. I did the CEDR course. It was a 5-day course, effectively a 3.5-day course and 1.5 days of practical exercise. And it was a great course. I can't knock it as a course, but that wasn't my training. My training was 25 years of dispute resolution. And I think that's the issue. And it goes on to another thing in the UK that's a big complaint. And I don't know if I'm sure it'll be published everywhere because everything is. CEDR produces an audit. They've just produced their latest one. And it talks about how many mediators there are and this tiny percentage of mediators who have work. And I sort of struggle with why they're surprised with that every year. If people are going to use mediators, they put their trust in someone who understands the process. So I'm contacted almost, or certainly on a weekly basis on LinkedIn by people who tell me they've just done their mediation accreditation, or they did it last week, last month, last year, and they're a bit puzzled as to why they don't have any mediation work. And I've gone to the point now of more or less a set response, which is you need, you don't have to be a lawyer to be a mediator, but you need to have some experience. You need to be taking something into the mediation room, whatever that might be. You know, I know someone who is a doctor who's a mediator and does just medical and is fantastically suited for that, but brings years of being a doctor. I see that Yemi, you have your hand up. You can only ask a question if you put your camera on.
Okay, so we're going to thank you so much for that. That just raised so many other questions, but I'm going to put that on the back seat. Mr. Akisoya, I see your hands up. Can we just quickly take your comment before I take the comments in the chat room?
Yeah, it's funny. The last sentence Andrew just made is a symposium discussion on its own. I can build over 40 questions on that last sentence he made. But let me hear from Mr. Akisoya before we get back to it. Yeah, let me unmute him. Yes.
Okay, he's here.
Yemi, I know Yemi. Oh yeah, good. I said only if you put your camera on.
Yes, I'm on. Hi, Andrew.
Great to see you.
Same here. It's interesting the comments you make, and it's one of the things that I have labored about. And I think this comes back to those of us who are practicing mediation. First of all, from a positive perspective, I don't think it takes 5 days to train a mediator. I think actually that's a misunderstanding totally. It takes a lifetime to train a mediator. And if you had been watching or listening to Vikram Singh's series about the evolution of a mediator, and I know you've been on it as well, you'll find that one of the things that it plays is that being a mediator is something that evolves over your entire life period, and it's a thing that you grow with. And that is one thing that is unique, I think, to mediation, not to law, not to arbitration. The second thing is that even at that, you find that most persons who come into mediation actually have some thorough background in something else, be it in banking, be it in law, be it in finance, in some other things. So they already have that. They have that grounding, which makes them already prepared. And I think what is happening is that within the mediator circle, we owe ourselves a duty of self-preservation by beginning to introduce standards. We are guilty of making everyone think they can be a mediator. That is our fault. and it is bouncing back at us. So we ourselves have to blame, and the solution lies with us. And lastly, I'll say this, because I'm not, you're on the hot seat. My seat is.
Oh, you're saying some great stuff. Gives me a break.
So the final thing I'd like to say is that with mediation, there are a lot of misconceptions, and for some persons, even in the mediator field, we look at mediation as just give and take, something to settle, whatever it is, almost like what I call very, very pedantic, very pedestrian. And I don't think that is sufficient. Even if you had the most rigorous 5 days, even a rigorous 15 days, what is actually responsible for your quality as a mediator is a combination of three things: the thoroughness of your background training in some other discipline or profession. Number two, the thoroughness of your background in terms of certain other experiences of life, which goes throughout your entire life history. And thirdly, the attitude that even we as lawyers bring to it. I think rather than see it, I'm contradicting myself sometimes when I think that lawyers actually have a basis to say that, in fact, they should be more disposed to be mediators than others. That's it. I'm done.
Yeah. Okay. Sorry. I'm sorry. Before you go, I'm just going to ask one question that ties into all what you have just said. Are mediators born or made?
A combination of the two.
You have to be born. You have to be born to be made.
No, I'm the core. Yeah, the core essence of being a mediator, because this ties into what Andrew said about his litigation experience and what he feels being a mediator. So this goes to and Mr. Kisa, you always say something that mediation is a way of life. So actually, so some people, no matter how good they are, cannot be good mediators. So it's not a function of being trained. It's just the very essence of who they are. So it just ties down to the question: are good mediators
I think that'll
born or made?
I think that'll be an unfair comment, because in life, people go to finishing schools. When we say mediators are born, not made, we're not saying that it is an innate talent that has to be, in which case you can apply that to virtually every other profession. There are some medical doctors, for example, whose bedside manners is so fantastic that simply sitting down in their office, you begin to feel better. And there are some that are not like that. When we say mediators are born, not made, it's more like we're saying mediation is not something you practice just as a theory, but more like in the kind of thing, because I'm picking, Andrew, it is what you said. It is Andrew, and I must emphasize this, that don't let me be on the hot seat. You are on the hot seat, and I'm not changing that with you, whether you like it or not. So you'd better stay on your seat. But I'll say this, that generally, mediators need to be called to. Mediation is a skill that has to be cultivated. It's not just learned.
But I think what it is, and I don't disagree with anything you say, at all. But I don't think it's any different from any walk of life. So I went down the law route, and when I went down the law route, I actually happened to live for 2 of my 3 years only with medics. And my social life became around medics, around the hospital. It was a fantastic social life while I was there. And I actually contemplated and looked into, after my law degree, doing a medical degree and becoming a doctor. And if I might well have done it. And there's lots of fields within, let's say I did it, and I'm sure I could have been a good, decent, if not a good doctor in certain fields, but not in others. So if I think I'm pretty clumsy, I'm pretty sure that whatever I chose to do in medicine, I would never have become the most amazing surgeon. I don't think I would ever have had the skill. And I'm using that as a drawn out. I don't think there's any difference between a mediator. Some are good and have something that gives a natural ability to be able to connect with other people, to get other people to talk about themselves, to get other people to change their perception of things, and some people can't. And I actually think, I was asked on one, what do you need to be a mediator? And the first thing I said was personality. And that's a starting point, and not everyone has it. When I mediated and saw over in, however many it was, hundreds of mediations as a mediation advocate, when I was acting as counsel, sometimes the mediator would walk in and he or she would have zero personality, and you knew no mediated settlement was ever going to happen. And if I look through, all the lawyers I've known over the years, there are many who are much cleverer than me, I would say, if you can measure how clever someone is, but weren't necessarily as good lawyers. Because there are certain skills you need for that, and it depends on the type of law that you're practicing at the time. So I think all these things happen. I think there is something. The problem is, for me, the issue is there is a huge issue, and I've talked about a lot around mediation training. It's actually, dare I say, I'm trying to contain my language on it because I feel quite sickly about it. But it is, in many cases, they are selling a lie. They are selling a 5-day course that gives entrance to a profession. They say, do this course, you can be a mediator, you can mediate. And the point is, you can't. You just can't. Because no one's going to employ you if that's all you're bringing to the table is a piece of paper that says you have a mediation accreditation. And what I was saying before, that's the problem. If you have that existing, of course you're going to have a lack of respect for the profession. Because you can't teach in that time the bits that I learned along the way as a lawyer for 25 years, understanding what happens in dispute resolution, what doesn't happen, what does happen. And you can't teach life experience. So I take two things into the mediation room. And it doesn't matter if it's a highly commercial case or a family dispute. I take my knowledge of dispute resolution, but I also take my life experience. And I can't act as a mediator unless I bring both into the room. So when I have, and it's often young people, come to me and say, I got my qualification 6 months ago, a year, 3 years ago, I've never worked. What can I do to be a mediator? And I say, well, let me ask you a question. When you, let's say, you are able to get retained as a mediator tomorrow, what are you taking into that mediation room? What is it that they don't have? Because that's the point. You have to bring something in that they don't have. Otherwise, they'll settle the case themselves. And that stumps most people because they can't think what they have. And so when a young person asks me, what can I do to become a lawyer like you became, to become an arbitrator, to become this, I actually say to them, what do you do now? And they may tell me what they're, whatever they're doing. And I say, become the best you can at that. Because that's how you progress. When you are the best at what you're currently doing, let's say they are a very junior lawyer, be the best you can at that. that gets recognized, and then you get something else, and then you get more experience. And I think that's the lesson for many, many young people throughout the world at the moment, is stop looking ahead and concentrate on what you're doing, because you have to pick up experience along the way. And that's going to make you be able to do more things as you get older.
Wow. Wow. That's deep. You know, the generation now is, I want it right now. The thought process of, you know, the young people is, I want it now. They just want to, you know, it's a microwave mentality, and concentrating on what you do now and becoming the best on what you currently do is a process.
Yeah.
It's not, you know, it's just not going to happen over, you know, this is something that happens over time. And what I've come to realize is I think there's this new way of thinking, this get it quick, oh, I'm an overnight success. That notion of being an overnight success is an illusion, because the night could have been 20 years. You just weren't there at that period in time.
Exactly.
Wow. Okay. I have a lot of questions, but I'm just going to go to the comments.
Yeah, Abby,
Yes, Fola.
I'm sorry, Abby. Yeah, Andrew also raised a very valid point, which is an elephant in the room I never addressed my mind to, is the issue of the training of mediation and churning out of mediators. You know, if
that's
so
one of
many
the questions I want to ask. But go ahead.
So if so many organizations are springing up and training people to become mediators under 2 or 3 days without an avenue for them to teach, for them to experiment, I don't want to use the word experiment, but for them to experience what they have been taught.
Hands-on experience.
Hands-on experience, then it just makes nonsense of the training, for want of a better word to say. Because, like Andrew, to have people who walk up to me to tell me that I'm a mediator, and I ask them, have you mediated? They say no. And I'm like, when did you become a mediator? That's when I now use the word like this. And when did you become a mediator? They say 3 or 4 years ago. And you ask, so if you've been a mediator for the past 3 or 4 years and you have not mediated a single case, so can you call yourself a good mediator? So the question now is this, and they not asked me a question, but if I've been trained to be a mediator and I've not been given cases to mediate, how then can I have a hands-on experience? So they throw the baton back at me, and I'm like, okay.
That raises the question.
I don't know, just a comment.
Yeah. So I'm going to introduce the elephants in the room then.
Okay, but you know what Fola just said now raises the question, and we've had this conversation. So what happens is, when you are asked that question, how do I get to learn hands-on, get hands-on experience on mediation?
Yes.
And then the people in the mediators, the active mediators that have hands-on experience, what they throw back is, it's a confidential process.
Exactly.
So it's for me, it's like a catch-22. For people who are not working as mediators, who do not have the opportunity, they're stuck in between, the devil and the
devil and the Red Sea. Yeah. Can we take him?
That is a problem with it. That's a problem with it. And it's a problem because certainly I can't speak about Nigeria, but in the UK, there is a limited amount of work and many, many more mediators. But I guess that the point is there anything wrong with training, let's say, young people about mediation? Absolutely not. Is there anything, is it wrong training them as if you're saying, when you finish this course, you'll be ready to go and be a mediator? That, I think, is the problem. So leaving aside, because, and someone put in the issue of mentorship, and that's something that has been raised before, and I think is a really valid thing. I think as I put up, the elephants in the room are this. If you are talking about serious commercial disputes, those who are in those disputes want someone experienced to come in and assist them to settle it. And so it's pointless pretending. There's lots of people who are doing the mediation accreditation in their late teens, early 20s. It's highly unlikely that they're going to be appointed to that sort of thing. It's just not going to happen. And there's no point pretending that it's going to happen. But the question is, they're not simply appointed. Why in these commercial disputes are people appointed? Are they not being, and older people are appointed? It's not simply because of age, it's because of experience. And so I think that's why it goes back to really that as a mediator, you need to bring something into the room. And that's what, when you teach mediation, you've got to be teaching that as well. We're giving you a skill that you may be able to use, perhaps even immediately if you can find some use for it. But this is a skill that you should understand. For example, if you're a lawyer, to understand that resolution is not simply in the court. That's why we're teaching you. But there's so much more for you to learn before you necessarily are going to be in the position where you can use it. And I think if you could build in going back, as I saw as it flashed up, a mentorship, that would be great. But you then have to be recognizing in the same way, if I take the UK bar, that it would have to be something like a pupillage. It would have to be for a long period of time. And what you would have to be saying is the same as you say, it's a limited number of people. We have—
So mediating and articling.
Yeah, exactly. But we have 2 pupillage places in my chambers for 300 applications. So you'd have to be ruthless and be saying, this is, if we're going to have a proper training in place, it's going to be limited, and then it's going to be on merit. But you still have this catch-22. It was fine as a barrister in my early 20s doing a year pupillage and then starting, because I was then able to pick up the tiny court cases. They're available. But the big question is, are the tiny mediations available? So there's so many plates to spin you are going to deal with this. But I'll finish on this. Whatever is decided is better than what you currently have, with effectively thousands of people getting accreditation around the world every year, with no increase in mediation. And many of those thousands expecting to get work. So CEDR gives a really, I've heard someone at CEDR give an example. I think it's a big panel. There's about 80 to 90 people on the CEDR panel. But CEDR has probably trained well in excess of 10,000 people, well in excess. And that gives you, so that's the principal trainer around the world. That gives you an idea that they themselves know that they can't even put the people, it's the tiniest fraction that will ever make it to their panel.
Okay, well, great. Andrew Parsons, you had your hand up.
You're on mute, Andrew.
Oh, sorry, I've stayed quiet for now. I want to listen to what everybody else says.
Okay, great, thank you. So Daria, you had your hand up. Can you please unmute yourself?
Hi, everybody. Hi, Andrew.
Hi,
really nice to have you. So I was just going to talk on 2 things real quick. I would say these are like my comments. The first thing I was going to talk on was with regards to personality. Mr. Akisha always says that mediation is a way of life. Aside from the fact that people say mediators are born, I personally feel that you can actually train yourself and know yourself if you really want to go into mediation, in the sense that if you know your personality isn't your strong, it doesn't go with mediation, you could pick up the skills to actually improve. Now that is just on one side. The next thing I was going to say was about this issue, the elephant in the room, this issue about getting trained as a mediator, but they're not having ample real life on the job opportunities to actually garner experience. So for someone like me, the first thing I did, or the first thing what I'm doing is I'm using real life situations around me. I kind of look out for disputes between people, and I try to sort of practice the skills I've learned during my mediation course. That, okay, look, I need to listen to both of them. I need to put these skills into use until when I'm able to get more real life experience. But I use what I see every day. I use disputes I see every day, conflicts around me. It could be my family, it could be my friends. I just try and use that to learn. Then internship and volunteering. We could volunteer at places and it will be for free, but the experience that's needed, we could get that. That's just my 2 cents. Thank you.
Thank you so much for that, Dari. Thank you.
Yeah,
Okay, so
can I just come back 1 second? I mean, I think that's an excellent way to look at it. And it's a very mature way to look at it because you've picked up skills during the training. So I'm not, my feeling is there's a lot to be gained from the training and you are putting that to use where you can. And what you either know or don't realize is how that will assist you to develop as you go through life, and will, may have an effect on your mindset, etc. in terms of what you're doing, whether you're a lawyer, whether you're in business, etc. So all that is relevant. The best thing we can have in this world that we have at the moment, full of conflict, is people who are thinking in a conciliatory way. So I salute you for that. Okay, so we have quite a few comments in the chat box, and I'm just going to go through them. The first comment is from Nathalia, and she says, I still love the wig and gown somehow, but with the much I know and the success of mediation, I will choose the latter any day. I totally agree with you on that. Andrew Parson would like to hear more from Nathalia on her comments. Then the next comment is from, Nathalia again. My mediation training was a week of rigorous experience. It was quick, interesting, and I knew my career path in mediation was birthed. I must say that mediation is a learning process because you keep acquiring knowledge from different challenges you encounter in different cases and between parties. We never stop learning. That's so true. So Uyo says, I believe it's a mindset. This is part of the individual, be it learned or innate. Okay. Yes, then, okay. Yes. So mentorship is key. I think that, there's a comment from Fumi, says that's deep. I'm sure that was in reference to the conversation we just completed with Andrew. That was deep. Okay,
So
yes.
I think it was to do with me saying be the best you can be. Be present and be the best you can be, what you're currently doing.
Yes,
okay.
I have a question. So from what you talked about, what I heard was there's a proliferation of mediation trainings, and you said something about structure. So would you enlighten us? Does that structure exist in your climb?
Do you mean the structure for mentorship and that sort of thing?
No, to the training and the proliferation of mediation training.
In the last year, since the pandemic, the proliferation of online training. So you get that certificate sent to you via your email at the end of it, rather than be handed it, that the numbers have greatly increased. There are names of mediation schools. If you go on the I can't remember what it's at, the CMC, which is sort of the self-appointed mediation council for the UK. It's accredited about 30 schools now. There's no overseeing of the quality that it's given. For me, it's a mistake. They've got it wrong, because you're not producing. It's not as if by doing this, you're creating more work, or you're creating a situation where those who might need mediation know about it anymore. It's quite selective. And I think that's the issue. For me, what I'd like to see, because when people say, well, what do you want to happen? I'd say, I want to see the public educated about mediation. That, for me, is the huge task. I'm always slightly surprised. I don't know why I'm surprised anymore. I mediate almost every week. And I will have people in front of me, some of whom are in big corporations who have been through litigation on more than one occasion. And so often there are individuals who this is their first mediation. And you think, how have you gone through dispute after dispute after dispute and not used it? So I can tell you, I had one, it was a couple of years ago now, where it was a contractual case, pretty straightforward, but it was a contractor that was contracting all over the UK. And they had a dispute with one of their contractors in one part of the UK. And it was a claim, I can't remember the exact figures, but close to $1 million was being claimed from them. And they had a number, it was actually to do with 5G, to do with the laying of cables and masts and that sort of thing. And we had a mediation, and whatever the figure was, let's call it 750,000. And in one day we settled. And I remember we settled for about 450,000. And all the way through, in the paying party's side, the party that was engaging all these contractors all over the country, there had been one man who had introduced himself, but the whole time he was on his laptop doing this. He didn't have any direct involvement. And we did the settlement, and at that stage I was going from room to room as the lawyers were doing the thing. And I happened to be in the room, and he suddenly looked up from his laptop. And he said was effectively the in-house counsel, the contracts manager, whatever the title was, and it was a very big, one of the telecoms company. And he said, I haven't been taking part the whole day. He said, you see, I've been on my laptop. He said, what I've been doing is I've been reviewing the whole 5G contract with all these different contractors. And I've been working out. And I have seen that over the last 2 years, we have spent in excess of $3.5 million on legal fees. And we have lost, and that's just the fees. We have had to pay out lots of money. And he said, this case, we had a claim against us for, let's call it $750,000. We've just settled it, including costs, for $450,000. The whole cost of this mediation, including all the lawyers and the mediation fees, is well under $40,000. And he paused and he said to his in-house legal, why have you never mentioned the word mediation to me? And that really, and that's not a unique case for me. How can it be? So we're concentrating on new young people coming in and educating, but an equal story is lawyers don't change. So when you're talking about lawyers being antagonistic to mediation, they won't change. Clients make lawyers change. Big business will make lawyers change. And it's the lack of education of the public in general, and that includes all commercial, that for me is the real issue. How can it be that that CFO had never heard the word mediation before and had been signing over check after check after check in respect of disputes? And that's the future in every country. It's the people know what a lawyer is. They know to go to a lawyer, but they don't know to say, I'm coming to you, but I want you to mediate the dispute, because they don't know about it. And that's the issue, that's the problem. And so we can sort of beat ourselves up a lot about the training and different things. What we should be doing is finding a way as mediators to make sure that the public knows about mediation. And I'm still asked by educated people, I don't mean lawyers, but by educated people, well, what's the difference between being a mediator and being a judge? What's the difference between being a mediator and being a lawyer? The public doesn't know. Or let's put it this way, a small section of the public knows.
Okay, well, great. I'm just going to hand over to Sola. He's going to take
Yeah. Okay. So yeah, Andrew.
Thank you so much.
If you had the opportunity of no, let me rephrase. Now, if of course mediation is growing, but if we are looking at an accelerated growth of mediation, should emphasis be more on the end users or on the lawyers?
So I think on both. I think lots of mediators, and when I train mediators, so I actually do one of the accreditations. I think where there are many mediators who make the mistake of not appreciating what the relationship between the lawyer and the client is, and thinking that they can get in between. And they fail to remember, because remember, even mediators have egos. They fail to remember that those people have been living this dispute for years, sometimes, before the mediator is involved. So for me, one of the most important things, if parties have got to mediation, is that I respect that relationship. Because the worst thing, and the thing that can absolutely guarantee you no settlement, is when you, as the mediator, do something intentionally or by accident to drive a rift between the client and the lawyer. And some mediators try and do that. They think that's a solution. But in my eyes, it never is a solution. So you have to respect it. What you have to do is work with it and within its bounds. And you may know, and there are many occasions where, as the mediator, I know that the best thing I can do is to say to both sides, I just would like to be in a room with the two MDs, the two CEOs, whatever. You know, the two people who ran the corner shop, the business, whatever it is, I'd like to just be in a room with them. But there's a lot of work to do before you say that. Because if you just go in and say it, then you're undermining the lawyer. And so I think the question is, it depends on, the answer to your question is, of course, it depends on the case. Great things can happen when you get principals talking to principals, but it won't happen if you destroy the relationship or you undermine the respect that the client has for that. And what you've also got to do is recognize you don't know everything about the case as the mediator. You know a percentage, and you don't know generally, because it's very rare that you're ever provided with the advice given by the lawyer. So
Sure.
You don't know what the lawyer has said. And just because the lawyer is saying in front of the client something, you don't know that's what they're saying when you're out of the room. So respect is the key to this. And carrying them both forward is very important.
Okay. Yeah, I'm sorry to take you back. There's a question from Loretta within the framework of, she goes like, I'm curious, are there alternative careers that young mediators can explore beyond actually mediating?
Anything. I mean, I think so I don't do family mediation, no? But I've had the pleasure of going through a divorce. And in the UK, you have to go through, I see, Abby, you're laughing when I said that. You have to go through a mediation when you get divorced. And if the mediator's sitting there in my divorce mediation had been a 20-something, 20-year-old something, I'm not sure there would have been any point continuing. Because what would that 20-something have been bringing into the room to two people who were getting divorced, having been together over 20 years themselves? So that's family. Yeah? So the person who mediated actually was a lawyer as well, and was bringing a lot into the room in the sense of experience of what would happen going to court, etc., etc., etc. And that's why that person could mediate. In my personal case, the mediation wasn't successful, but we'll leave that. That's a whole nother interview. But I think the same is, if you ask what's the alternative, don't think about mediation. Think about, the fact is you're unlikely to be chosen as someone in their 20s to mediate. But if you are brilliant at what you do, and it doesn't have to necessarily be law, if you are great at what you do and you build a reputation in that, and you have confidence in that, and it has a dispute element to it, you can then find that in years to come, you will pick up on your mediator skills and be able to mediate. And so I think that it goes back to the bit I said, is it's so important. And I think, for me, I find it very, very interesting. I've got no idea how many years left of work I've got, hopefully quite a few, but I'm in the last, I'm in the latter stage, and I find it quite fascinating how people view work so differently to how I did when I started 35 years ago. And it comes down, I did a talk to one of the London universities, and I was asked a question, as I said before, how can I be a lawyer like you, an arbitrator, a mediator, whatever? And as well as giving the answer I just gave about, you're a second-year law student, the best thing you can do is get the best grades in the second year. That's what you can do now, because that's going to set you up for what you get in the third year. The point I made was, I don't think I ever would have asked that question when I was your age. And this isn't me trying to be patronizing, or anything. It's me trying to work out, why didn't I ask that question? And I think it came down to this. My road wasn't great, but when I finally did it and got qualified and got into the chambers where I was, all I knew was I had to work. They would give me work and I would work. I wasn't looking ahead all those years. And better people than me have said it. I'm sure some of you know Simon Sinek. And he talks about this. He says, there are issues with young people, but none of it is their fault. It's all and one of them, he says, is bad parenting. And it's it's an interesting and also funny thing. But the one thing he says is, whatever the reason, it's not criticizing young people, is nothing has changed when people go into organizations. They go in generally at the bottom, and they're at the bottom of a mountain. And he says, nothing has changed in terms of seeing the top of the mountain. And at the top of the directors, the partners, the whatever. Yeah. And everyone years ago going in would look up and see them and think to themselves, well, I might be there, I might not be there. You know? And in a sense, that hasn't changed. And he says when he goes into places, and he does lots of work for Google and Amazon and Microsoft, he talks to people, to young people, and they say about the job, and they say, I'm thinking of leaving. And he says, why? And he says, well, I've been here 9 months and I haven't made a difference. Mm. And what his conclusion is, where he's come to is, nothing's changed. There's still a mountain to climb. The difference is the ability to see the mountain that you have to climb. And it's what, I think, Abby, is what you were saying, it's that instantness.
Yes.
People can look up the top and they see that, but they don't see the steps. So me thinking, I never asked the question because I never knew if I'd make it to the top, but I could see there were lots and lots of people between me and the top. And at every stage, they got to the next stage because they worked. And that was the element. And that's why I think the emphasis is on. And I say I've got lots of young people in my life, whether they're my children, nieces, nephews. And I say that to them when they say, I want to do this, I want to do that. And the key is, great, but you've got to work at it. There's lots of steps. It doesn't come automatically. And I think that's the same. That's, in a way, that's what's happened to the mediation with all this immediacy of giving a 5-day training. It's as if it's there without seeing there's still a lot of work to do after those 5 days.
Okay, Andrew, thank you so much. Can I crave your indulgence to add another 10 minutes to what we have on ground? I know it's almost time to go. Hope you don't mind.
No, at all.
Great. Now, I have one final question on the angle of antagonism of lawyers before I move over to hear your perspective on mandatory mediation. Now, do you think where mediation is concerned, do you think lawyers need to learn, relearn, or unlearn?
Learn or unlearn what? Mediation or their own?
No. The advocacy skills, for want of a better way to put it, the litigious angle of advocacy. Do you think they need to unlearn some certain things that we have been taught in law school as far as the practice of law is concerned for mediation to be able to take its pride of place as one of the most effective means of dispute resolution? Do you think we need to unlearn some certain things we're taught in law school?
I think they need to learn. So I think there's lots you have learned already. It's just education. It's part of the education. The best way they're going to learn it is if the clients tell them they want it. And that's going to, lawyers have to be trained in a certain way because you're trained in an adversarial way. And it's not a criticism of lawyers. If they're going to court, there's still someone making the decision and they still have to persuade that person to make the decision in their client's favor. What needs to happen is a greater emphasis. As you use the word dispute resolution, for me, that's a very new word, very new, resolving a dispute. And I think perhaps, and I actually use this phrase in my, when I'm mediating to parties, I say I'm not actually a dispute resolver because everyone uses that word. I see myself as a dispute container. I can't change the past. I'm just going to hopefully help you contain your dispute so you can move on to other things. And I think that's the lesson. But I meet plenty of lawyers. As much as I can sit here and give you some negatives, I meet plenty of lawyers who are incredibly good dispute resolvers and dispute containers. So that the learning process is happening, but the biggest change to lawyers happens when clients tell them they want it to go this way or that way.
Okay, so Andrew, when we look at the concept of containing something, there is no assurance that what you have contained has been resolved, right? Well, there's a possibility that we have just boxed it somewhere. I'm just trying to picture what it is to contain something as opposed to resolving something. The possibility of containing something does not mean it has been resolved. We might have just put it in a particular place and just left it there. So within the context of what you're trying to explain, do you think the word containing the dispute is the way to go? Just
Well,
thinking outside.
I think where we part is on, I think when I get a settlement, I've contained that dispute. I haven't resolved it. I haven't been able to turn the clock back and stop those goods being defective. I haven't been able to turn the clock back and stop the person having lost their house or their piece of land. But what I have been able to do is contain the fight.
Okay.
So it's no more.
Not letting the blood.
So they've
Okay,
got
not letting.
their compensation, and that's it. So I think what the problem is, we've given it, it's not a problem because people understand it a different way. For me, resolving is something different. You know, resolution is much deeper. And I think that's, if you say to people, like I sit there and I often deal with insurance cases, and on one side, there are people who've been through, they didn't get paid out. They may have lost their business as a result of not being paid out. And here's the insurer coming to now pay them late. I can't resolve that. I can't get them their business or their house back. I just contain where they are at the moment. And I think that, so I think it's, you know, they're all words, but I think it is the same, you know, and if you get legally, you get the settlement and it's binding and they get compensation, that's it. It's the end of it. But it helps people to see who come into mediations where a lot of, and you know, I only deal with commercial, but there's very often a real personal element to it. And I think when you tell them, you know, I'm not here to be able to change what's happened in the past, they understand. And it helps them to think, okay, so that's not going to change, but what can I do today?
Okay. So one question from before I hand over to Abby. What are your thoughts on mandatory mediation? Some schools of thought believe that for mediation to take its pride of place and to, for want of a better way to put it, to circumvent the influence of lawyers on clients, that it is imperative mediation is made mandatory, so that at least if you're able to drag the horse to the water, the choice of the horse drinking from the water is entirely left to it. Since mediation is a party-driven process, I would like to know what your thoughts on that is.
So I'm not a fan of compulsory mediation because I think mediation has to be voluntary. Parties have to be there. But there's a move amongst the judiciary in the UK to have some element of compulsory education. As you say, drag them to the trough. You can't make them drink. And 75% of litigation started in the courts in the UK has a value of under £10,000. Now, that's a lot of litigation at very small value. And there has to be some sense in saying it is a waste of time, all those matters going to court. So we are going to direct them into a different let's use your word, into a different way of resolving them. And I can see the force in that. Your difficulty is, what level do you go up to? Where do you fix that? Do you fix it at 10,000? Do you fix it at 50,000? 250,000? Which one is it? But at low value, if you said 10 or 20,000, you're covering 75% of disputes. That should not be going to court anyway. So that you then can have some sort of great success rate on it. The reality is, it doesn't matter how big, how small, if someone does not want to settle a case, and the line I've changed in how I approach this in my mediations, I say, we're here to see if settlement is possible, not that we're here to settle. Because I've seen the subtle difference. But if people don't want to settle a case, you won't get a settlement, whether it's a 10,000 case or a 100 million case. But in terms of the sort of work I do, making it compulsory will not help. What the judiciary has done in the UK is gone from encouraging mediation to making it an expectation. And if you don't do it, and you go all the way in court and you win, you're going to be penalized on costs. And I think that's the best they can do. So most do, not all, still not all, but most will still do mediation. The issue we have in the UK is when they do it. And some of them, I have many mediations that have been going, disputes been going 5 years, and they come to a mediation a few months before trial because they know they have to. And that's as close as it gets to being made to do it.
Okay.
Well, great. Thank you so much. I have loads of questions, but I'm streamlining them. So where do you see mediation in the next couple of years? And, well, let me let you answer that first.
So the pandemic has had a big effect.
Would you say that's positive? Would you say it was a positive effect?
Yeah, it's had a positive effect.
Okay.
Okay, not the lawyer's choice. So it depends what happens, and we're all wondering here. We're going through, and we're hoping to come out of our lockdown. We've now had a setback because of the Indian variant, so you don't know. But it's gone like this, and in terms of COVID, but so has mediation. So it for me and for many mediators, when lockdown started, I had a few bookings in the diary, and they went over to being remote online mediations, and then it went quiet. And then suddenly, I'd say, so that was in March, I'd say in July even, it started to get busy. And then, wow, it got busier than it had ever been, all doing remote mediations. And so I asked someone I was mediating with, a solicitor who I knew. I said, you don't normally come to mediation so soon. And he said to me, well, the reason we're here is not my choice. It's because we haven't been able to offer our clients. They've asked us, when is my hearing going to be? And we have not been able to offer them any certainty. So what we have done is said, when they've said to us, well, what else can you offer me? We've said, well, there is this thing called mediation. Let's go to that. So it changed the speed with which things were getting to mediation. So I was seeing, and I still am seeing, cases coming to me at a much earlier stage than I had done for the previous 4 years. And I think that's the great change if it continues. And it's all about lawyers letting it continue. It's about clients knowing about it, because it won't be the same clients in 2 years, and we may slip into old ways. But if it doesn't, then we'll see things coming to mediation faster. And the other thing we'll see, so I'm really excited. I have my first face-to-face mediation since the last relaxing of our lockdowns, which I think was October last year.
Oh, wow.
So I had my last face-to-face was March 20. I then had one in October or even November 20. And this is my first one on Monday, because we're at the next stage from the 17th, opening up.
Okay.
But what is really different is I have already had 4 hours on Zoom with the parties, 2 hours with each.
Okay. That sounds like exciting. We're back to face brick and mortar.
We started the mediation remotely. We've covered a hell of a lot of ground already. I may be speaking to them on Sunday. Certainly we haven't stopped bouncing emails since we had the face-to-face on Thursday. And so the mediation isn't starting on Monday when we meet face-to-face. It's
continuing.
That's exactly the word. Every step is a continuation. And that's the future. That's the future. And if we don't settle on it, we'll just go back to Zoom the next week. And that's the beauty of it.
The flexibility of mediation is truly an asset. It's the beauty.
Before COVID, it was a 1 day. And if you didn't do it in that 1 day, it was very difficult to get the parties back to talk about it again. And that's the huge change. That I think is, it's a game changer. And I'm not the only one doing it.
Okay, great. That's amazing. So my other question is, I have two more questions and then we'll wrap it up. Do you see mediation becoming like arbitration in the near future with all the structure and the regulations? Do you think that would give it a little more, I don't know what the word is, a little more swagger?
I hope
That's
not.
not the right word, but would it give it a little more structure?
No, I hope not. And I think in a very short answer, I'll tell you why. Arbitration was before my time, but I've been told this. It was advertised as this fantastic new thing that was going to be better than litigation and cheaper. And it's proved to be as complicated as litigation and even more expensive. So
Yes.
if you regiment something, you increase the costs. And the great thing is, mediation of big disputes is not cheap, but it is hugely cheaper than going through a whole trial and an arbitration. So I don't want to see it, but it will be taken over again as arbitration was by the lawyers. We have something called adjudication in the UK. It was designed to have quick 28-day decisions for construction projects that were ongoing. It was hijacked by the lawyers 15, 20 years ago. It's now a really expensive, complex, and complicated process. Don't let that happen to mediation. Let's keep this flexibility.
Okay, great. I totally agree with that. Thank you so much. So my final question is, what would your advice be to people who are looking to come into mediation now? And then we're rounding up. I'm handling after that.
Can I answer that? Because I've seen Loretta put a hand up and then take it down. And I've just seen Loretta's comment where she says, oh yes, we Gensers, Generation Zs, have a very different perspective when it comes to work. So before I answer, I'd be really interested to hear from Loretta as to tell us why she put that comment and what she means by it. Loretta, are you with us?
Okay, I've unmuted her. Loretta, over to you.
Oh yes, I'm with you. I could relate strongly to what you said about, speaking to young people now, and they seem to be working in places like Google, Amazon, and then they want to leave because they feel like they're not making a difference. And that was why I put that comment there, because a lot of us in the Generation Z group, we like to make a difference. We want to do work that makes an impact. So how can we find that? I mean, definitely mediation helps people resolve their disputes in a way that is more flexible and easier than going through the stress of the court. But I think the first question I asked was about alternative careers in mediation. So how can young people, knowing that people are not going to have us come and mediate now on disputes, what else can we do? Is there anything like mediation marketing, for instance? Is there what other areas can we find a way to fuse mediation into and make an alternative career out of? I think that way we can also find ourselves, making a difference, making an impact with these same mediation skills, even if we can't get a chance now, since we're still young, to start mediating on matters.
Well, I think you're a long way there and a lot further than I was. I've got no idea, Loretta, how old are you, if you don't mind me asking?
I'm 23.
Okay. You're a bit younger than me, I can tell you that. I don't think I would have even known to ask those questions. So I think it shows such a maturity that you're thinking about those things. And I think that's so important. And I guess I don't have, I've already said, I think you try and do the best that you can in what you're doing. But I guess throughout not just my work, but my life, I've seen conflict. There's conflict everywhere. It's all around. So what you have as a young person who has presumably had mediation training is you have an ability to keep an eye on that. and you have an ability to act on it. And I think it was you, Oldare, that you said you use it where you can. You use the skills you have where you can. And I think when you become certain, proficient in an area that you have, then you will find a way, if there are disputes in that area, to be able to add this string to your bow, which is mediation. For me, I guess it was, and for most lawyers, I worked as a lawyer for 25 years, and mediation is part of the legal profession as such, or the litigation, the dispute resolution. So I was able to use those skills, but it's not limited to that. I mentioned the friend I had who's a doctor who also mediates and mediates incredibly well. So I think it really is working on what your passion is. If you ask me, can I go out now and be just a full-time mediator? I'd say probably not. It's going to be incredibly difficult. But I think if you work hard and do well at what you can do, it's fantastic. I guess I've forgotten, Abby, what was the question that led me on to linking it with.
Andrew,
your advice?
Yeah, no, I'm sorry, before we take the advice, can I just expand a bit of the narrative Loretta just asked Andrew? Now, I asked this question at my last session about the disconnect between the older mediators and the younger mediators, because I have a mentorship platform of 170 young, mostly young aspiring mediators, where we tend to talk about issues like this. Now, do you think a solution to this will be niche mediation? Someone like Loretta, who is 23, is a Gen Z. We have some Gen Zs that go into business. People might be able to relate with someone of our age handling disputes that come up in that area, as opposed to other areas. Like for someone like me, I'm 40, I don't do family mediation because of the age and experience, but I tilt more towards commercial mediation because of my years of experience, which is over 10 years at the bar. So do you think niche mediation can be a way of getting getting younger mediators into mediation? That way, it's the arena, it's the space. They can actually own that space. Because when you're talking about TikTok and the like and everything, do you think that could also be a way of encouraging them?
And when you say, do you mean, when you say mixed mediation, do you mean?
No, niche mediation, specialized kind of mediation, probably something that has to do with like, maybe we're talking about stuff like TikTok, the general stuff young people do. Yes. Do you think that could also be an avenue rather than having them wait till they garner that age, which is not necessarily experience, that age before they can really come into full stream mediation?
Don't get me wrong. Young people are amazing and they do amazing things. So I don't see why not. It's finding your niche. That's the key to this. So mediation is about using whatever word we use, whether it's containment, dispute resolution. It's about doing something where there is some sort of conflict. And if there was a TikTok issue, a young person would be far better than I would. I'd just be embarrassing at it. So I think it is finding a way. I guess, I don't take from what I'm saying that this is knocking the younger generation. If anything, it's the opposite. It's so, the vastness, the potential is so much more than I had. The opportunities are incredible. I think what comes with that is the question marks for young people. So the young people in my art, you in a sense have so much choice that you're not sure which way to go. You are bombarded with so much information all the time. You're not sure where to go. And I think that's the difficulty. But I think there is still many things have changed, but many things haven't changed. And I think it still is, we don't always do what we want to do. I don't know if I wasn't one of these people who always wanted to be a lawyer. I actually came to law later. People starting, I was 4 or 5 years later than most, and there's various reasons. I did other things. I worked in a stockbroker. I worked as an accountant for a while. I tried different things, and that hasn't changed. People try things and you find something that works. But the main thing that hasn't changed is whatever you do, if you want to do something else in there, you have to prove yourself. And I think that's the key. That's the key to it. But I love the I think the aspirations of young people, and I'll finish on this because we had dinner with my 2 young nieces yesterday, and one of them is 5, and we were talking about what they want to do when they grow up. And the 5-year-old, she's 5.5, she said, I don't know, maybe I'll get the job looking after all the planets. And if I can't get that job, I'll just have the job looking after planet Earth. And I think that's beautiful.
Okay.
Her second best is gonna, she wants the #1 job, which is looking after all the planets. But her second job is just going to be looking after planet Earth. That's not a bad aspiration to have at age 5.
Not at all. So quickly, before we take Mr. Akisoya's comment, Uyo's hand has been up for a while. Uyo, can you please unmute yourself? Briefly, let's just take your comment before we go over to Mr. Akisoya. I noticed your hand was up. Uyo, okay, yes.
I think I did that mistakenly.
Oh, okay, then, no problem.
I can actually contribute something when it comes to the niche issue. I would say that for me personally, I'm not yet 40, but I do family mediation. I have a passion for it. I have settled cases in it. And well, when you talk about age, mediation, and having a specialty, I think it depends on the individual. If you can be good with different topics of different, what would I call it now, mediation aspects, let me use that word, then all well and good. But if you are the kind of person, like I would say, there are certain people that when it comes to the career thing, from the time they're 5, they already know what they want to be, and they stick to it.
Yep.
There are other people that they could change their mind at any point in time. They develop interests as they go. So now it depends on you as an individual. If you're the kind of person that can handle different aspects, all well and good, do it. If you are the kind of person that would just prefer to focus, be it family, be it commercial, like you said you rather do, then that's nice also. And I also want to encourage the young ones out there. Yes, we've said a lot about having the experience, having the age factor work for you and all that, but don't be discouraged. Just do what you can, where you can, like I said, and in time, you find yourself handling mediations just the way a very experienced person would do. So that's it from me.
Yeah, thank you so much.
Absolutely beautifully put. Thank you.
Okay, Mr. Akisoya, over to you, sir.
Well, first of all, I must say that I was not disappointed at all in coming in. I think, Andrew, you did great justice to the entire time and the questions asked. Thank you very much. I also regret that Andrew Parsons did not come on as he promised us, but I'll leave that for a future date. Andrew, you're muted. I can't hear you. Okay. There are 3 things I'd just like to add in closing.
We're watching the whole thing. I haven't said very much. I've just been watching, listening.
Well, great. Years ago, when I was in my secondary school, one of the first aspirations I had was to become a concert pianist. I was fairly good on the piano, and in fact, at the end of my A-levels, I had done my grade 8 Royal Schools of Music, and I was preparing to do the LRSM, the licentiate diploma in piano performance.
Wow.
And I wanted to be a concert pianist. And I remembered my teacher then, a retired Air Force Major J.G.C. Allen. He called me aside once and said, Yemi, you are very good. You are extremely good. In fact, I think you're incredibly talented. I thought I was going to say, you're going to make a great career. He said, let me tell you two things. He said, most persons who you're going to be competing with as a concert pianist began to play at the age of 3. You started at the age of 14. You've done quite well for what you've done in the last 5 years, but the competition is stepped against you. He said, secondly, let me let you know this. For every one great pianist that you see on the records, he said there are 1,000 others who are aspiring to be that. And so don't be left in any doubt at all that, you can just get it up there, that for every one person, for every one Arthur Rubinstein, there are 3,000 others merely aspiring who never made it. The moral of that is, I found later that that did not apply only to music or to piano. It appears to law, it appears to mediation, to every very successful lawyer that we see who's prominent and making lots of money. There are 10,000 others who are just in the periphery. And I believe that mediation is not going to be any different. The most important thing is to work at what you want, hone your skills, and get on with it. With respect to Gen Zers, there's one thing that I find, I thought we were going to say, which when Loretta made a comment, which is that, yes, a lot of Gen Zers are in business. And it might be interesting to know whether those Gen Zers, when they have their disputes, will be more predisposed to having a Gen Z mediator. That could be a selling marketing point that you might want to consider, because it will sell more than you think. And finally, Andrew, I totally agree with you. I'm extremely passionate, almost fanatic about not letting, I'm a lawyer, you're a lawyer, but not letting lawyers take over mediation. And I agree that regulation, when it is unduly done, will eventually, first of all, make it easier for lawyers who are used to dealing with the rules and regulations to take it over. And more so, it will increase its costs. So I believe that as mediators, we have to very jealously protect that turf. And I can tell you that I am on that squad already, that I'm not going to I'm going to do my best to resist the takeover of mediation by lawyers while I have breath. Once again, thank you very much, Andrew. It's been great having you. Fola, thank you for inviting Andrew. Abi, you guys have done great. Thank you. Well done. That's me stuff.
It's been a pleasure. It's been a real pleasure. And 1 hour has become 2 hours, so it's been even more of a pleasure.
Double pleasure.
I think the next one should be there in person when all this COVID has gone.
I agree with you on that, Andrew. I agree totally. I'm looking forward to it myself.
I don't know about you, but I am very tired of looking at the green dot and looking through the screen. It's
Thank you. Thank you so much, Andrew. I don't know, can you all hear me? I think I see
very clearly. Very
great.
clearly.
Yeah. Thank you so much, Andrew. It's been an interesting and insightful session as always. Mr. Kisoya, Andrew Parsons, and every other person that has tuned in. We appreciate taking time out to contribute to some of the topical issues we've had to discuss. And next week, we'll be having the director of the Citizens Mediation Center in the person of Mrs. Oseni with us to discuss contemporary issues surrounding mediation. Wish you all a lovely week and God bless. Thank you, everyone.
Can we get people's cameras on so we can take a photo?
Oh, that would be nice.
That would be awesome. Yeah, that would be awesome. Now, that's funny. Nobody has actually ever asked for this before. So let's do this. Can everyone please put on their cameras? Let's just take a good picture. Like I said to Andrew, thank you, everyone. As many of us as can, let's put it on. Okay, I can see Loretta, I can see Dr. Edele. Okay, Mr. Kisaya's video is up.
Don't be shy. Even you, Andrew.
Yeah, Yeah, Andrew.
Jamie, you turned your camera off.
Yeah, can everyone put it on the camera? I can see Mrs. Ladiga from
Loretta,
Uduai.
Sarah.
Mrs. Sheila,
Yeah,
Sage,
Mrs.
where are
Sheila.
you?
Yeah, I think she's somewhere.
Yeah, I
I'm
see
here,
her, I
but
see
my
her.
time, but I'm here.
Okay, then I'll just
All right, everyone.
count.
Have a fantastic evening.
Thank you so much, Andrew.
Thank
Thank you
much,
so much,
everyone.
Andrew. Thank you, Fola and Abi.
Thank
Well
you. It's been a
done.
real pleasure. It's
Thank
been
you
a
Thank
so
you,
much.
Mr. Kismaya.
And please stay
Thank-
safe and well. That's the most important
Oh,
thing.
yes.
You too.
Thank you so.
You too.
You too.
Thank you so much,
For
everyone.
that picture taken?
Bye.
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 Lovely seeing you.
Bye-bye.
Hey, Ayo. Okay. All right then. Thank you so much. Everyone have a good evening.
But thanks for having us. It was a great session.
Thank you, Ayo, for joining.
Yeah. Bye.